of state arbitration. Arbitration is distinct from judicial settlement in 5 respects. 1. A composition of arbitral tribunal carried. While a judicial settlement concerns international dispute settlement in pre-constituted international courts and tribunals, arbitrators are to be chosen by parties to a dispute on case-by-case basis. 2. The applicable law in the case of judicial settlement. International courts and tribunals are on principle called upon to render the judgment on the basis of international law. In the case of arbitration, however, the parties may require an arbitral tribunal to apply specific rules which are not necessarily binding rules of international law. While normally international law is applied in arbitration. 3. Procedure. In the case of arbitration, the parties may agree procedures necessary for arbitration in flexible manner, whilst procedures for judicial settlement are predetermined. 4. Publicity. Unlike the International Court of Justice, the proceedings before the arbitral tribunal are not public unless the parties in dispute agree otherwise. 5. Speed of proceedings. Normally arbitration will take less time than a case before the International Court of Justice. The selection of arbitration. The state parties to a specific dispute can freely determine the composition of an arbitration tribunal unless their treaty obligations provide otherwise. While there were some cases where a sole arbitrator was appointed, at present the practice of arbitration by only one arbitrator has become less common and more often than not. An arbitral tribunal consists of 3 or 5 members. Independence and impartiality of arbitrators. Independence and impartiality can be regarded as key requirements when appointing arbitrators. In fact, an absence of independence and impartiality may lead to the loss of confidence of the parties and undermine the validity of arbitration. Process of arbitration. Mutual consent of the parties to a dispute provides a foundation of arbitration. The parties at dispute may refer an international dispute to arbitration by 3 ways: dispute settlement treaties, a compromissory clause, and a compromise. First, the state parties may agree to submit all or special categories of future dispute to arbitration in multilateral or bilateral treaties entirely devoted to the peaceful settlement of international disputes. Second, the parties to a dispute may agree to submit all or part of their future disputes regarding that treaty to arbitration by a compromissory clause in a treaty. A compromissory clause is a provision which provides for the settlement by arbitration of all or part of the disputes which may arise in regard to the interpretation or application of that treaty. Third, the parties to a dispute may agree to submit disputes to arbitration by a special agreement or compromise after occurrence of the dispute. The term compromise refers to an agreement for the immediate reference of a specific dispute to settlement by a judicial or arbitral body. In other words, compromise means the ad hoc treaty instrument directed to the settlement of a specific existing dispute. According to the Model Rules on Arbitral Procedure prepared by the International Law Commission (ILC) in 1958, a compromise shall specify, as a minimum, the undertaking to arbitrate according to which the dispute is to be submitted to the arbitrators, b. the subject matter of the dispute, and, if possible, the points on which the parties are or not agreed, c. the method of constituting the tribunal and the number of arbitrators. Scope of the jurisdiction of an arbitral tribunal. The subject matter of the dispute is a key element for determining the scope of diction of an arbitral tribunal. By defining the scope of issues narrowly and if the parties in dispute can prevent an investigation of wider questions which more problems than it would resolve, or exclude from arbitration particular issues, negotiation or some other means of settlement is considered more appropriate. Extremely narrow formulation creates considerable difficulties for an arbitral tribunal in the process of arbitration. An illustrative example is the 1988 Taba arbitration, which had the location of certain pillars marking an international boundary between Egypt and Israel. In this arbitration, these two states set out Pillars